Hey guys, welcome back to my channel. Welcome back to Real Talk Bougie. Guys, do you know who this guy is right here? If you don't, this is Sheriff Marcos Lopez. He was arrested 3 weeks ago with his cohorts, Carol Cote, Sharon Federick, and Sheldon Weatherholt, along with his now three co-defendants or co-conspirators. They arrested his wife this week. Okay. Homeland Security came through the same way that they arrested the sheriff 3 weeks ago, which I'll show you this real quick if you had not seen this. He was asked to go to the Homeland Security office, and he went in and he was informed that he was going to be charged. There are allegations that there was a massive, as they say, massive gambling operation taking place in Osceola and Orange County. He had been held in Lake County, which is a neighboring county. I think part of Kissimmee straddles into Lake County. But he had been held in Lake County, although he's sheriff of Osceola for the past 3 weeks. He got out last night. But the interesting thing as well is that they arrested his wife. Let me let you guys see this. I don't know that he was aware that she was in this investigation. What I understand, she was handing over maybe it was a W-9, some sort of a document to show the source of funds for his bail. These two are estranged. They've been married for quite some time, but allegedly have been separated for a number of years, but still are married. And part of the stipulations of their bond is that there is no communication because now they are officially co-defendants. And ma'am had been under investigation along with him. It's pretty serious. So they stopped her in traffic and arrested her out on the streets. And this is Homeland Security. This is posted to their X account. But yeah, she was pulled out of her vehicle and arrested. As you can see, Homeland Security, they have their vests on, and taken into custody, and she remains in custody. Sheriff was released yesterday. I'll show you that. A lot going on here, a lot of moving parts. And let's see the sheriff getting out yesterday from after 3 weeks in Lake County Adult Detention Center. So what they're saying is this lady here to the right with the side part is his lawyer. It's possible these two, the person in the taupe, the person in the blue, are the bail's bondsmen. He is on a GPS ankle monitor tether, and they were able to verify his funds. He had a $500,000 bond per charge. He's got two charges, so a $1 million bond. And we know that bonds are typically 10 to 15%. And he was able to find the cash, and with a source that is verified to not come from illegal funds. So he's out. His wife is still locked up. So, and they're not able to communicate. So we don't know how that's going to go as far as him being able to assist her, because it appears that she was trying to assist him. And I wouldn't say that that's what got her pinched. She was probably under investigation anyway. But she is not permitted to have any contact with her husband. So this is him taking off. and not one word to the press. And I don't blame. I mean, 3 weeks in jail, that's pretty tough. Okay. So this is him getting out. This is them trying to huddle coverage, and he does not want to be seen. The disgraced sheriff, and he has been temporarily replaced. There will have to be an election, but he has been temporarily replaced by Ron DeSantis, the governor, and he is officially suspended from his role as the Osceola sheriff. And this is a huge scandal, federal investigation. If you can hear the helicopters overhead, pretty crazy. Anyway, let's pivot, guys. We are going to pivot and go to the hearing for his wife, now one of his co-defendants, and not a good look. This has been a bad month for them, right? So Robin Severance-Lopez, that is her name. Robin Severance-Lopez is the wife of the now suspended Marcos Lopez. And let's get into the arraignment. So before I share her first appearance, let's take a look. When I plug in the case number for Sheriff Lopez, right here, Marcos Lopez, all of these names come up. So this particular case number is attached to 5 defendants at this moment. We've got Marcos Lopez, former sheriff. We've got Carol Ann Cote. We've got Sharon Denise Federick, Sheldon Weatherholt, and we've got the sheriff's wife, Robin Lynn Severance Lopez. So here everyone is, and this is looking like quite the situation. Let's go ahead and go over to the first appearance and hear about bond and the stipulations of release, and we'll talk about it at the end.
Good morning, ma'am. You are before me this morning on a Lake County warrant charging you with conspiracy to commit racketeering. I did find probable cause for that offense. Your attorney, Ms. Yard, is here, as well as the statewide assistant prosecutor, Colleen Monroe. Before I determine an appropriate bond and any pretrial release conditions, I will ask both of the attorneys for their input. Ms. Monroe?
Yes, Your Honor. The state is asking that a $400,000 bond be opposed. That in addition with the request by way of our motion for source of funds to be established. We're also asking that Ms. Severance-Lopez be placed on a GPS monitor, surrender her passport and firearms within 24 hours of her release from custody, and have no contact with Marcos Lopez. First, as it relates to the nature and circumstances of this particular case, Your Honor, it is a serious case. It is a first-degree felony with which involves essentially a multi-million-dollar enterprise involving illegal gaming activity and an array of other offenses. 6 people have already been charged, and the defendant before you is now the 7th. Ms. Severance-Lopez's role is essentially is alleged to have been that she served the enterprise primarily through her partnership with Marcos Lopez, her husband and the then acting sheriff of Osceola County, where she helped to facilitate the movement of illicit money and receipt of illicit payments from other co-conspirators to Lopez, which is believed to have reached to be at least $600,000 to $700,000. Our evidence includes witness testimony, bank records, text messages, and email correspondence, a small sample of which is offered in the defendant's probable cause affidavit. Of special note is most recently, upon the arrest of Marcos Lopez, the defendant was interviewed by law enforcement agents. When asked whether she knew of any of the co-conspirators in this particular case, she denied it, but was then presented with a photograph of her along with certain of the co-conspirators at a holiday party, at which time she acknowledged her dishonesty. The evidence against her, Your Honor, is compelling and in large part irrefutable. She has engaged in some travel, Your Honor. Our information indicates that she travels regularly to Palm Beach County, and a large portion of her family lives in the state of Michigan. She also has had some international travel, including trips to St. Croix, Dominican Republic, and London, England. In addition, Your Honor, she has meaningful financial resources, which interestingly cannot be explained via legitimate employment or a business source based on law enforcement's review of her bank records and other filings. Most recently, in April 10th, 2025, in a pending divorce case between her and Marcos Lopez filed out of Brevard County, she filed a financial affidavit which reports a net monthly income of $1,337, yet reports she has approximately $123,000 in a bank account in addition to other assets. And at her arrest on yesterday, the defendant had 2 bank receipts in her possession indicating she had made 2 deposits, one in the amount of $117,000 dated June 11th, and an additional $60,000 deposit dated June 13th, both of which were made approximately 1 week after Marcos Lopez's arrest. This is in part combined with the allegations of her involvement in this enterprise leads to the need of a source of funds inquiry. The enterprise in this particular case was predominantly a cash business, and since the beginning of this conspiracy through even today's date, the defendant has had access to large amounts of cash, including deposits, withdrawals, and acquisitions that far exceed her legitimate employment, business, or retirement income. We are also, as I'd indicated earlier, Your Honor, asking for a no contact provision. They've been, Ms. Severance-Lopez and Marcos Lopez have been separated since at least 2019. A divorce was formally filed in 2023. They do not reside together. And at the time Marcos Lopez was arrested, he indicated to law enforcement that they don't talk very much. Yet, nonetheless, upon his arrest, she offered a property towards his collateral to help post his bond. They do not operate as a married couple. I would suggest to this court that the stronger relationship between them is that of co-conspirators, and an order of no contact is necessary to prevent the furtherance of the conspiracy and any opportunities to tamper with evidence. In addition, Your Honor, and I will rest on the state's motion for a source of funds inquiry.
Thank you. Ms. Yard, do you have a copy of the state's motion?
Yes, Judge.
Okay. Your position, ma'am?
Your Honor, I understand that there's been a finding of probable cause. I do want to talk about the allegations in the probable cause affidavit, at least to be considered as to the weight of the evidence. The allegation in the affidavit is that Ms. Severance-Lopez is involved in this conspiracy because of a single email sent in 2019 where she forwarded somebody a W-9, which that individual is believed to be a co-conspirator, Ying Zhang. However, the forwarding of the W-9 doesn't demonstrate that she received any payment. It doesn't demonstrate that she was aware that any payment was being made. A W-9 is provided to somebody that a business is providing income to, not receiving from. So here, the forwarding of the W-9 is not as inculpatory. The state is alleging that it indicates that she accepted some sort of fraudulent funds, but all a W-9 does is provide an individual with the ability for the individual to provide the business with their information. It doesn't demonstrate any receipt of funds. There is no receipt of funds from Ms. Severance-Lopez or her business indicated in the affidavit. And as to her denying that she knew the co-conspirators, yes, they asked her if she knew Ying Zhang, and they report that she said no. The email indicates that the person that she was emailing, their email address began with Kate, and that she entitled that email beginning with "Good morning, Kate." So it is obvious that she knew this person as Kate, not as Ying Zhang, who she was emailing. They then indicate that she denied knowing somebody named Krishna, but as soon as they showed her the photograph of this individual purported to be named Krishna, she admitted that she knew the person in that photo. She didn't deny it when showing the photo. Here, the photo again is not inculpatory. It's a photo that is stated to have just been taken at a Christmas party. The reason that this is important as to the weight of the evidence is that the evidence purported to be being used against Ms. Severance-Lopez at this point negates any pattern of racketeering activity. Of course, for there to be conspiracy to commit racketeering, the state is required to show that there's a pattern. A single email sending a W-9 with no proof of any behavior after 2019, the last involvement here that they allege was 6 years ago, doesn't show a pattern. If anything, it shows an isolated event. It was a one-time email that was sent per Marcos Lopez. That's indicated in the text of the email. There is also no indication here that she joined this criminal enterprise. Here it indicates, again, in the face of the affidavit for this arrest warrant, that she was separated from Marcos Lopez at the time, that she indicated that she was only willing to send this W-9 on a single occasion because she was separated. There is zero agreement for her to join any criminal enterprise here and commit any pattern of racketeering activity. Of course, conspiracy requires that the government be able to show that there's a specific intent to engage in 2 or more predicate acts. Here, they've only even alleged a single act, whether that act is an act of racketeering or simply sending a W-9 is not a crime. And again, nothing in the 6 years since then. In terms of what the appropriate conditions of pretrial release are here, I believe that the state's motion causes some confusion, so I'd like to go through that. This, of course, is a first-degree felony. Ms. Severance-Lopez is constitutionally entitled under the Florida Constitution and the Florida Rules of Criminal Procedure to reasonable pretrial release. The rule specifically addresses what the court is to consider in determining what that reasonable pretrial release should be. And the rule expressly states that there is a presumption in favor of release without monetary conditions, and that even when monetary conditions are necessary, that the court shall, and the rule uses the word shall, impose those least restrictive conditions to reasonably protect the community from physical harm and assure the presence of Ms. Severance-Lopez at her future court dates. Here, considering those gradations, right there, the court is required to consider whether personal recognizance would be sufficient. If not, the court is required to consider whether an unsecured appearance bond would be sufficient. And of course, then it goes on to a bail bond with appropriate sureties. The factors in considering where Ms. Severance-Lopez should fall in those gradations include consideration of the nature and circumstances of the offense. Again, Ms. Severance-Lopez's only tie-in here is sending a W-9 to somebody that is a co-conspirator in this alleged racketeering offense. The weight of the evidence against her is not great. It's not evident. In terms of her ties to the community, Ms. Severance-Lopez is the mother to a 15-year-old child. That child lives with her. He was at her home just yesterday. She has resided in the Osceola County area for more than 20 years. Prior to that, immediately prior to that, she lived in the Orlando area. So her length of residence here spans decades. She is an American citizen. So in terms of the court considering her immigration status, that is also a factor in her favor. The court is to consider employment history. Ms. Severance-Lopez is employed. She works part-time at a job that she has had for more than 2 years. And her financial resources are not great. The state here is alleging that she has $123,000, but then asking for a bond of $400,000. So they're asking for a bond more than 3 times what they allege she even has. Her mental condition is clear. She doesn't suffer from any mental disease or defect or mental health disorder. She has no record of prior convictions. She's never been in trouble. These are, again, all express factors that the court under the statute is to consider. She has no record of previous flight to avoid prosecution. She has no previous failures to appear in court. The court must consider whether she is a probable danger to the community. The allegations here are completely non-violent. The court is allowed to set conditions to reasonably assure that the safety of the community from physical harm. There is zero basis to believe that she is a risk of physical harm to the community. Of course, the source of funds is a factor. It is one of many, many factors, including the list that I've already gone through. She was not on any kind of court supervision at the time. Another factor is the probability of intimidation to victims. Again, there is no reason to suspect that. It's been approximately 3 weeks since the majority of the co-defendants in this case were arrested. There's been no allegation that she did anything untoward to tamper with evidence or intimidate victims. She's certainly not subject to any reclassification or enhancement. So under the totality of the factors in the statute, the source of funds being only one of those factors, the tips certainly in favor of minimal conditions of pretrial release for her. In terms of responding to the state's motion that was filed late yesterday at 5:02 p.m., I would like to go through that. In paragraph 1, the state attempts to argue that this court is not bound by the 5th DCA's opinion in Sparrow. And in Sparrow, the 5th DCA held that, quote, to the extent that a court inquires at the first appearance hearing as to the source of the funds available to post bail, it is for the purpose of ascertaining whether the bail set is sufficient to secure the defendant's appearance, not to deny him pretrial release. So the reason that this is important is the state is essentially arguing in its motion that the court can place a hold on somebody, Miss Severance-Lopez here, to require proof of the source of funds. The 5th DCA in Sparrow expressly declined that. They said that for the court to continue to hold somebody after the bail, the monetary bail and conditions have been met, amounts to a pretrial detention. Here, the state wants to argue that 3rd DCA case law, 4th DCA case law hold differently, but this court is within the confines of the 5th District Court of Appeal. This is valid law. This Sparrow opinion was issued 10 years after sub 2F was added to the statute as a factor. In fact, in the paragraph with the holding, the court cites to 2F, indicating that it is aware that the statute allows an inquiry into the source of funds, but the 5th DCA holds that to order any extension of detention based upon that is improper. It is simply a factor that can be considered. In paragraph 2, the state cites to some obligation that the court has authority and obligation to look into the surety. The case cited for that, Fleury, doesn't address that at all. It is certainly not the holding of Fleury. The state cites no valid authority for that proposition. In paragraph 5, the state again here correctly indicates that the source of the funds is one of many factors to be considered, but improperly indicates that there is any support to hold her after the bond is posted, given the 5th DCA case law. And it's not just the 5th DCA case law. It is the plain language of the rule of criminal procedure. It is the plain language of the statute that these are factors for the court to consider. Neither the rule nor the statute create any sort of jurisdiction for the court to indicate that there is a hold requiring proof of these funds. In paragraph 6 of the state's motion, Again, the state claims here, and I quote, that the Florida statute, quote, clearly authorizes a trial court to hold a defendant. That is simply false and contrary to the 50 CA case law. It is, again, a factor, but the statute and the criminal rule of procedure do not authorize extended detention. In paragraph 8, again, the state cites that the court has this jurisdiction or authorization to require that the bondsman make this proof of things to the court. Again, the state cites to nothing besides the rule and the statute in support of that allegation, and it is not in the rule or statute that the court has that authority. In paragraph 9, the state here espouses some sort of philosophical disagreement with the bail bond system that's used in Florida. They indicate that the current, quote, practice of bail bonds agents is not to require collateral. Again, here there is an entire Florida chapter which is chapter 648 that regulates bail bondsmen and what they are allowed to accept and what they are not allowed to accept. The state here is essentially indicating disagreement with those bail bondsman regulations and asking the court to do something outside of the custom and practice and outside of the plain language of the rule. In paragraph 10, again, we just have mere assertions unsupported by any evidence here that the funds that Ms. Severance-Lopez would use to post any monetary bond would be the fruit of illicit proceedings. Again, there is no indication that Ms. Severance-Lopez, the state admits that she has been separated from Mr. Marcos Lopez since at least 2019. The state admits that there is an active divorce. There is no evidence that she benefited from any alleged activity of Mr. Marcos Lopez, or that she received any funds that were illicit from him. There's certainly no allegation that she received them directly. So here, there is no reasonable probability that the funds she would use would be illicit. She is 50, Ms. Severance-Lopez is 50 years old. She has apparently $123,000. She has worked in her life, number of jobs, the one that she...
Guys, it's the view of the inside of the pod for me. If you've never seen the inside of a pod, we're getting a real-time look. She's standing here for her first appearance Zoom, and you see kind of life happening behind her, and it doesn't seem to be a very full pod. Maybe it's because of her situation of being the wife of the sheriff of a neighboring county. So maybe she's in kind of a more empty pod with less inmates. But yeah, let's finish this up. We're about halfway through, but she's still sitting in jail. As far as I know, her husband was released yesterday. So today is June 27th, Friday. And as of yesterday, June 26th, Marcos Lopez was released from jail. He got out yesterday, and he is free. And his wife is still sitting, his estranged wife is still sitting in custody of Lake County, and has to get a proof of funds. So I guess the irony is, as they stated, that she was passing a document to someone, and I don't know if that created a red flag or whatever the situation was, but she was arrested on the 23rd, so 4 days ago, taken into custody and remains in custody until she can prove where she can get the funds for her release. And interesting situation.
She currently has. She's had for the last 2 years. There is no reason to believe that the money that she has is illicit, and the state can't prove that any of it is. Again, the rule requires the least restrictive means. In paragraph 12, the state again incorrectly argues that this mere factor of looking into source of the funds somehow empowers the court to require additional collateral. The citation, and this is important, in the last sentence of paragraph 12, the state is quoting, indicating that the court is allowed under 903.105 sub 2 to require additional collateral for all or part of the remaining portion of the bond. But the state is quoting there from the appearance bond statute. That does not apply to whenever a bail bondsman or surety is used. So here, while the court may under the rule require the additional collateral if there is an appearance bond, there is nothing in the statute, nothing in the case law that indicates that the court can do so for a surety bond. Again, just in concluding the response to the motion, the state is asking to stay her release without authority. That would require a pretrial detention motion. There's no rule, statute that allows that, and it would in fact be contrary to established binding 50 CA case law. The state wants the hearing as to the source of the funds and qualifications. Again, that only applies by the statute to an appearance bond, and they want to assign a collateral to the entire monetary amount. And again, here, that is certainly not the least restrictive means necessary to assure the appearance of Ms. Severance-Lopez at further court dates. The state just made an allegation that Ms. Severance-Lopez has no business with Mr. Marcos Lopez other than as co-conspirators, and that the fact that she's willing to put up collateral towards his bond somehow indicates that she's a co-conspirator. The reality of that is that they have a child together and they are co-parents. Ms. Severance-Lopez is not a co-conspirator. She is a co-parent. Of course, she doesn't want the father of her child to remain in jail if he doesn't need to. Here, considering the least restrictive means, Ms. Severance-Lopez is in a different position than her co-defendants in that she is not charged with substantive racketeering. And we know that's because there's not a pattern of racketeering here that can be proven. There's not more than one incident that could qualify as racketeering activity. But she is different and should be considered aside from all of her co-defendants in that she is not facing that substantive charge of racketeering. There's, again, no proof or even allegation in the affidavit that she personally profited. This is a nonviolent crime. All of the factors under the statute and rule point towards a very reasonable bond being imposed here. She did not flee after Mr. Marcos Lopez and the others were arrested. She remained in her home. It's where she was arrested yesterday. It was outside of her home. She does not have significant financial resources. The state has done this exhaustive investigation and believes that she has $120,000. So we know that a bond of $400,000 would be outside of her financial reach, and we know that a bond outside of her financial reach is tantamount to no bond. Bond is not allowed to be used punitively, and setting a bond in the amount of $400,000 here would certainly be punitive and intended to hold her in jail. Two of her co-defendants were released on the conspiracy count on a $50,000 bond. They are both released. They are no longer in custody. There is no reason to believe that Ms. Severance-Lopez should have a bond higher than what those co-defendants at $50,000 on the conspiracy count had. All of the favors point in favor of her, and there is no basis for the court to hold her pending proof of funds, given the evidence that the state has. and the plain language of the rule statute and the 50 CA case law. I'm asking this court to set a monetary bond of $50,000 or less in this case. Thank you.
Your Honor, if I may just be heard, just to clarify just a couple points, it'll just be brief.
Go ahead.
First off, counsel is offering a misstatement of the law as it relates to conspiracy to engage in a pattern of racketeering activity. She is imposing upon the state a greater burden than is on the state. Specifically, as it relates to a conspiracy, it is enough for a co-conspirator to knowingly and willfully join in on the plan, even on one occasion in this type of in this charge. That's by way of the jury instruction. So there is a misstatement of law there, but nonetheless, and in fairness to counsel, she has not had the benefit of the case file in this case. She has not had the opportunity to observe all of the evidence that we do have as it relates to Ms. Severance-Lopez. And I do, if Your Honor would find it helpful for your consideration today, I do have both the case agents, one from HSI and FDLE on the line, to speak to some of those things if Your Honor would so require. But so there is much greater levels of evidence than what your counsel has been privy to. And in addition, Your Honor, just to clarify, when we suggested to Your Honor that Ms. Severance-Lopez recently attempted to, or is offering to put up some property to support Marcos Lopez's bond, that was not offered to suggest the co-conspirator relationship. I was merely offering that to highlight that despite all of the other pending factors, the divorce, that they don't talk much and things like that, that occurred. It wasn't being offered to suggest a co-conspirator relationship between the two of them on that particular point. In addition, the state has in its bond request is factoring in the confusion and inconsistency in Ms. Severance-Lopez's filings, is the fact that she reports only a small legitimate income reports a small legitimate income, but then has access to unexplained, based on our review of the records, large amounts of cash, where when taken in conjunction with her alleged role in this multiple year operation involving an illegal cash business, creates reason to believe here and probable cause that that cash that she has come into access to is illicit. And as Your Honor may recall, yes, the state had argued that, yes, Ms. Severance-Lopez had filed with the court in Brevard County an affidavit under oath indicating that she had $123,000 in the bank, but that was also taken into conjunction with just yesterday, she made a almost $200,000 deposit, cash deposit into 2 bank accounts over a couple of days. And so we're not relying just on the $123,000. We are also including the approximately $177,000 that she had access to just within the last couple of weeks. So we believe she is of meaningful financial resources. We believe a high bond is necessary to secure her appearance. And moreover, Your Honor, as it relates to the source of funds motion, it is important to note that the Sparrow Sparrow case was focusing on the federal decision of United States v. Nebbia. It was calling into question the law as it applied in the state of Florida under the Nebbia decision. That was a federal law. That was what those cases were asked to decide, and we distinguished that in our motion. What is important is to consider that 903046 subsection F is Florida statutory law. It was enacted by the Florida legislature. It was signed by the governor, and it remains constitutional throughout the state of Florida. So counsel's arguments would be more properly asserted if she wanted to question the constitutionality of 903046 subsection F. So we are filing our motion pursuant to that authority and offered, Your Honor, additional law to show the distinctions between United States v. Nebbia and versus 903046 subsection F. Thank you.
Ms. Monroe, I would ask for a response to Ms. Yard's argument or part of her argument that you are requesting a bond significantly higher for this defendant than was already granted for some of the co-defendants?
The co-defendants, Your Honor, the co-defendants in this particular case were not alleged to have profited off this enterprise in the same way as the Lopez's. Marcos Lopez, through the assistance of Robin Lopez, collectively, as co-conspirators in this particular enterprise and as partners, are believed to have profited close to $1 million in this enterprise, based on all of the evidence that we have in this particular case. They are in a significantly different position than the other co-conspirators who had more ministerial roles. They were operated in employment capacities, got paid fees, if you will, small fees for their contributions to this operation. Whereas by way of their partnership, Robin Severance-Lopez and Marcos Lopez were operating as partners in basically capitalizing in large part through Marcos Lopez's position as the former sheriff of Osceola County in order to generate the kind of income that was coming in through this enterprise to them. And so that is the distinction between the co-conspirators and the Lopez's involvement.
All right, thank you. All right, the court is going to set a monetary bond in the amount of $400,000 for Ms. Severance-Lopez. Additional conditions of pretrial release are that Ms. Severance-Lopez surrender her passport and all firearms within 24 hours of release from custody, that she have no contact with Marcos Lopez, and that a GPS monitor be placed on her prior to release. I am also granting the state's amended motion pursuant to section 903.046 and would ask Ms. Monroe to provide a proposed order reflecting the granting of the requests of the state in that amended motion. Ms. Lopez, I want to explain to you the nature of the no victim contact order. You will be asked to sign a no victim contact order acknowledgement upon your release from custody. But that means that you are not permitted to have any contact whatsoever with Marcos Lopez. You can't see him, call him on the phone, text him, send him a Facebook message, or communicate with him by any means whatsoever. You're also not allowed to ask another person to communicate with him on your behalf, for example, to give him a message from you. Do you
She looks
understand
like
all that,
she's
ma'am?
in shock.
I also need to make sure you understand that this is a court order. It's between you and the court, not between you and Mr. Lopez, meaning that only another judge can waive the provisions of the no victim contact order. And if you are found to have violated that in any sense, it could lead to you being rearrested on additional charges and held in the jail, most likely on no bond, until your case was resolved. Do you understand that as well? Okay. Thank you all.
Thank you, Your Honor.
Thank you,
Oh,
Judge.
I neglected to indicate that Ms. Severance-Lopez's next court date is July 21st in front of Judge Welke at 8:30 in the morning for an arraignment. Thank you.
In Memphis, this is News Channel 4.
Okay, guys, sorry about that. Okay, so this is the deal. I mean, this is pretty crazy. So, you can tell she looks like she's pretty shell-shocked, sitting behind bars and getting her appearance with the judge. They're not giving any slack to the sheriff, so it's quite possible that what is going on right now, obviously, is a direct result of what's going on with her husband, and they want no commingling. They want absolutely no blurred lines for her and her estranged husband with what he's got going on. And to be quite honest, it's probably the best thing for her. Let's just be real, because at the end of the day, his charges are very severe, and if she is not in cahoots, if she is not part of this situation, if she is not considered one of the people that they are looking for in this particular investigation and this case, then probably really needs to stay out of it. Um, like her lawyer said, just because she was trying to help doesn't necessarily make her a co-conspirator. But according to the prosecutors, like she said, the prosecutor stated that her defense attorney has not had access to the case file. So basically, so to me, I kind of took that as you don't know what we know, and you haven't seen what we've seen, and this is what the evidence is saying, and and that and that's how I took it. So anyway, guys, you guys tell me. Now I am going to come back with some information regarding the arrest of these other co-defendants. You heard them also mention someone named Zhang. I'm getting that that name correct, so forgive me if I've messed up the name. But they said that there were 7 people and 5 arrests. When I looked up the case number in Lake County, which I showed you earlier. Let me see if I can pull it up again real quick. I see. When I look up the case number, you will see these folks. Basically, you will see. Let me take that down. Okay. So when we're looking right here up close, we're seeing these folks. So sheriff's wife, Robin Lopez, Severance-Lopez, Sheldon, Sharon, Carol Ann, and Sheriff Lopez, right? So that's what we're seeing, and then that's what we're seeing here, these folks, and then they added in Ma'am, who got arrested on the 23rd. Anyway, let me know what you think. Maybe this is a mess. This is a scandal. There's a federal investigation. Everybody was arrested by Homeland Security. It appears that Ms. Frederick and Carol Coates and Sheldon have been released some time ago. Sharon Frederick has a very interesting background, and we will get into that a little bit later. Comment down below. Let me know what you think. This is quite an interesting situation, and they said this gambling operation was had taken in well over $20 million. Okay, so this is huge. Anyway, guys, comment down below. Let me know what you think. Sheriff Lopez is in trouble, and baby is not going to be ending anytime soon. All right, you guys, take care. Thanks for coming through. Make sure to subscribe to this channel. Make sure your notifications are set so that when I go live, post the updates, you will be notified immediately. Thanks for coming through. Take care. Bye.